All right, all right, all right. What I like to do now is really just go through, um, we'll call it roll calling, right? This would be our version of text and roll, where I'd like everybody to share a little bit about what they do, right? What you're doing, where you're doing it, what's your niche in real estate, and 30 seconds, right? 30 seconds. The screen shows kind of the outline of what we'd like to know about each other. And again, because in if we were in real life, you get to meet whoever's in the class and maybe you need their help with XYZ or maybe not. So this is our opportunity to do that. So I'm going to do my version of roll call for the class and run through the different names. Let me see if I have all the access that I need. Mhm. All right. Maria, can we start with you? Maria was the Maloney. Can you hear me? Okay. Okay. So I got Maria. It's in the chat box here. Boom, boom, boom. Okay. Enrique, please unmute yourself and just kind of introduce yourself, what you do, where you're doing it, what you're hoping to get out of today's class.
Yes, my name is
Um,
Enrique. I do property management and real estate in the Woodlands, the Spring Conroe area.
awesome.
Now, I want to learn about the topics today.
The topic. I love it. I love it. And
Yeah.
Enrique, what's your license number?
My license number is hold on, 50. I have it on top of my hands.
Okay.
520195.
520195.
Yes.
Sounds like you've been around since the early 2000s. I love it.
Yes.
Awesome. Awesome. I have somebody here signed in as iPhone. Again, because we're giving credit, please do put your name. Do your best to stay on camera, just in case somebody from TREC walks in and says, "Yep, there's five people who didn't get credit because they weren't available the whole time." So that's that's kind of my way of trying to keep us all in line. So I have a person here that has iPhone, but I'm not sure who that is. Jared, can we have you do a quick introduction, please? Thanks, Enrique.
Yeah, I'm in Houston, Texas. Well, just south of Houston. I'm also an investor. I've got single family rentals. So yeah, and I was actually looking at a wholesale deal this morning that looked like a decent deal, but I'd be inheriting a squatter. So also curious about that.
Nice. So yeah, this is very timely for you. And that's what I'm hoping that we'll have a handful of people in the class today that have real life experience, real world experience, like right now on their desk that we'll use to navigate the course. You'll have the PowerPoint. I don't want to read to you guys, right? You'll have the slide deck, you'll have all of that. My goal is through our collective experiences that we actually have some real life scenarios that we can use to say, hey, here's what I did when I saw that. Here's what you could do when you see this. And then, of course, at the very end, there's one slide that says today wasn't supposed to be legal advice. It was just kind of a class. But yeah, Jared, do you need light? Do you need TREC? Do you need CE credits for today?
Yes, I do.
Okay. So your license number?
Yeah, 791894. Sales agent.
791-894. Okay. Okay. Cool. And I think you put it in the chat. So maybe I'll just skip that part in the interest of time for everybody else. Casey, quick introduction.
Hi, my name is Casey Barnaby. I'm a real estate agent in the Harris County, Texas area. I'm actually going through a personal situation slash issue that I need advice, information, and even a lawyer for an adverse possession. So when I seen this class, I'm more interested in the adverse possession versus the squatters. But yeah, and I was hoping to maybe offline get see if you have an actual lawyer for this.
Yes, absolutely. You're in the right place. And we'll talk through all of those different scenarios as I like to see them. Yeah, Casey, cool. I think we got June. June, you with us? I think one of my favorite things about Zoom is sometimes you sign in under your spouse's or kid's account and you're like, wait, why'd they call him my kid's name? I think I saw a message from June. Kamal?
Hi, good morning, everybody. I'm a property manager in the Houston area. I'm also a real estate agent. We do have a situation right now where a scammer was able to get into one of our properties and allow a family to move in. So I am
Oh,
very
no.
curious to learn about all the topics today. Thank you.
Absolutely. Absolutely. Yes, you are definitely in the right place. Marielle?
Hello, my name is Mariela. I go by Ari. My niche in real estate is veterans, so most of my business is done around Fort Hood. I'm a veteran myself. Um,
Thanks for your service.
and appreciate you. And the main thing that I want to learn today is the process of removing unauthorized occupants because I have a real
Okay.
I have a rental and I am planning on growing my portfolio and I foresee that that will be an issue eventually. So I just want to get
Yes.
ahead of the game and have the knowledge in case it happens.
Appreciate that. Thanks for sharing that. Um, we'll talk through a lot of those different scenarios today. So yes, Matthew.
Yes, my name is Matthew Hartman. I'm a real estate agent, property manager in the Dallas area.
Awesome, awesome, awesome. Megan. Megan and Molly.
I was going to do mine in the chat, but I'll go ahead. I'm actually a real estate agent in Austin residential. I want to just help advise my clients that might have squatter possibility or issues. And I myself actually own land in for about 25 years now in another state. And I'm always trying to, it's a very small little town. I'm always worried that before we get to build on it, that it's actually going to have probably squatters, so I'm always kind of trying to reach out to the title company and to the, real estate people there just to make sure they know who I am and you know what I mean? So hopefully that'll
Yep.
work until we're able to build. But yeah, anyway, thank you.
Yes, absolutely, absolutely. Let's do Shayna.
Hi, I'm Shauna. I'm on a property management company right now, and we're going through a lot of evictions. I kind of see that we probably might have somebody trying to squat in one of our properties. So I'm taking this class to just get educated and get a little bit more insight on how to handle the situation.
Okay, okay. Thanks for sharing that. Stacy.
Hi, my name is Stacy Lambert. I am a real estate agent here in Austin, Texas area. I do a lot of fix and flips, but also kind of try to specialize in pre-foreclosures. So I just want to make sure I'm well versed in the squatters' rights and adverse possession area.
Cool. Yeah, we'll go over a lot of things today, but definitely none of us will leave as an expert, but we'll have enough to be able to navigate situations as they come up.
Awesome.
Stephanie.
Hi, I'm Stephanie Arneal. I'm a licensed agent in the San Antonio area. And also my husband and my sister and brother-in-law and I own some property and they run kind of property management and they are getting very into foreclosures and that kind of stuff world. So this is just a great opportunity for me to be prepared.
Yes, yes, yes. Be prepared. And then last I have on my list is Tammy. Tammy, Tammy,
Hi,
Tammy.
hi, this is Tammy Busfield. I am in the Austin, Texas area. I'm a realtor here. I'm just interested in the topics.
Awesome. Awesome. Thanks everybody. And if I didn't call your name, it's probably because I had you as an iPhone or something along those lines. But make sure you put your information in the chat, license number and name, and we will make sure to get you the CE credits for today.
I'm sorry, can I introduce myself real quick? You called me
Yes,
first
please.
and I was having some complications with my
Yes, Maria.
desktop.
Yes, yes, I see you
I'm
here.
Maria Maloney. I'm the managing partner for a real estate brokerage here in Wichita Falls and a property management company. I also have some long-term rentals and I have an Airbnb here. So I just wanted to take this class to learn more. The more you know.
More you know. I love it. I love it. I love it. I love it. Um, so yeah, let me introduce myself. I am Damon Isiaka. I'm a broker, second generation real estate broker. I've been doing this since, I feel like I grew up in it. Without sounding like a silver spoon, like a trust fund baby, right? I grew up in it, kind of mowing all these grasses because my dad has, a handful of properties that we managed, right? So of course, as a teenager, I hated it because I was always kind of working. Back then, it was when we had houses with a bunch of mirrors, and so there was always a mirror to clean on any given weekend. So anyway, it was a no-brainer as an adult. I got into real estate in my early 20s, and I really haven't looked back. 2009, I did pivot. If anybody here is young enough to remember 2009, there was a huge market collapsing. I forgot the word we used back then, but it was a time. I pivoted, went to law school. Got to law school and realized that I was a lot more business minded than the typical person in law school. Luckily, I was doing a joint degree where I could do my JD and my MBA. So as we speak, I have a law degree, but I like to wear my business hat a lot more. So 99% of the business questions, let me rephrase that. 99% of the legal questions that I ask, I like to answer it as a business person. And then the 1% that is not businessy, then we need to have a litigator, right? And I always like to take this chance to kind of just introduce the difference between an attorney and a lawyer, right? As a society, we use those two words interchangeably, okay? But the difference is the attorney is the person that can represent you in your jurisdiction. So we'll call Texas a jurisdiction. California is a jurisdiction, okay? The lawyer has a law degree, whether they get it from California or New Mexico or Oklahoma, they have a law degree. The attorney is the person that can help you in front of a judge in your jurisdiction. Okay, so that's going to be the main takeaway as I talk is yes, I have a law degree, but I don't want to be an attorney. Okay, so I'll use what I know about law to answer business questions. And when it becomes a nope, we have to go litigate this, then we can get into finding the right litigant or finding the right litigator rather in your area. Also, my passion, this law school, is alternative dispute resolution. We call it ADR for short. I like to call it EDR for early dispute resolution whenever possible, because the idea is this. In a lot of scenarios, in a lot of squatters, there was a past relationship. Family members, for example, right? Tony stayed with grandma passes, Tony doesn't move out, Tony's squatting. And so we have a problem. We have a squatter problem, but it's not, I don't want to sue Tony. Tony's a relative. but I do need to have we do have a conflict, right? So in a lot of our scenarios, mediation works. It's cheaper, faster, a lot more confidential, right? Because any given lawsuit, as soon as you file it, it's public information, right? So I'll talk about mediation quite a bit through this conversation. And a lot of people will be like, well, wait a minute. So I have this person, I'm clearly in the right. They've squatted in my house. You want me to go kumbaya with them? No, right? We're not acting like go kumbaya with a criminal, right? And we'll talk through all of that. I hate to call them criminals, but you'll see why I use the word criminal as we get into the course. We're not talking about having a kumbaya moment with criminals. We're just saying in a typical scenario that you might feel like you need to run to the courthouse and go litigate, mediation, which is built into all of our TREC contracts, by the way, says, hey, let's have a conversation. If the conversation doesn't work, then we can run to the courthouse and we can go file. And because of the way mediation is set up, none of the information that's shared in the mediation is usable in the courtroom. There's a statute that protects it. It's a whole thing, right? And part of the reason why we do that is because the courtrooms are clogged up, right? They're very, very backed up. And so the system has an interest in us using mediation as much as possible. So that's my background, and I'll be happy to take questions as we talk. Even if it's in my slide, I'll be happy to answer it as it comes up, just so that I want to make sure that your thoughts and your questions are actually answered rather than squeezed in at the back end of it, right? So if you have Q&As right now, I'm happy to start with Q&As. That's just part of my being quirky, right? I act like we're interactive, but we're all in the same room. So I've heard a couple of people say different things about what's on their desk. Feel free to ask those questions during the conversation, and I'll do my part to plug it into the slides as we see fit. So today, our course is designed to help commercial and residential real estate agents, property managers, right, understand the difference between squatting, trespassing, adverse possession, and holdover tenancy, right? We'll definitely discuss how it impacts your listings and transactions, and then we'll talk about a couple of different legal pieces. I want to say Senate Bill 1333 and Senate Bill 38 are the main two ones that we'll really talk about. And one of them is designed to get rid of, right, tenants or evict people. The other one is designed to get rid of squatters. Okay? So the people that were evicting means at one point they had a right to that property, right? If you've ever had a right to the property, then you're not a squatter. You're just a lazy tenant that never got out, right? We'll call those holdover tenancies. Your lease expired in January. Here we are in March. You haven't paid, and you're still there. You're just a holdover tenant. You don't have any squatting rights because I allowed you at one point to give you the keys, right? So that's what we'll call a holdover tenant. The squatter that needs to be ejected rather than evicted is the person that, whether they moved in with bad faith, meaning they had a fraudulent lease, a fraudulent deed, or whatnot. We'll call those criminals, right? Because what else can we call them? They use some kind of illegal means to get into the property. And then the actual adverse possession, and I'll just jump into it and say, it's an old law, right? But it's still on the books because of the public policy that it brings. Imagine this. I don't remember when, trying to think back, I don't remember when Civil War happened, but imagine it's that year, okay? Tony goes up to fight the war, never comes back. Okay? Again, remember, it's back in those days, and I don't even know that the post office was as functional, whatever, right? So Tony never comes back. What the adverse possession law did was to allow me or you to step into Tony's shoes. Because again, back then, a lot of this land was farmland. So we want to make sure that Tony's crop gets harvested and makes it to the market. And so we put this piece in, this adverse possession law that says, step into Tony's shoes, farm his land openly, continuously, notoriously. There's a couple of big adjectives that's also added. But if you meet the elements of doing what Tony would do with this land for the statutory period, right? You act like Tony for long enough, then we as a society want you to have legal rights to the land. Now, when Tony shows up, if it's within the statutory period, then I guess Tony thanks you for taking care of the land while he was gone and takes back possession of his land. So that's why it's on the books. Okay. And so a lot of the people, a lot of the quote unquote squatters that we see nowadays, I like to say they kind of just learned how to do it from like jailhouse associations, right? So imagine the scenario where somebody gets picked up for trespassing. They're like, no, I'm a squatter. I want to evoke my squatter's rights, right? They end up in jail. They're telling their cellmate, right, why they're there. And their cellmate's like, oh, here's what you did to do well. Give them a couple of pointers on how to become a better squatter. They get released, they try again. Okay. So I feel like a lot of what we deal with nowadays is just those bad actors that have learned from other bad actors how to use the language and convince us, realtors and professionals, because I've heard stories where some of the squatters make it sound so believable that you were out of line, and it's because you were out of line that they're criminally trespassing on your land. And it's not okay. It's not okay. So we'll go through all of that during the conversation. Like I said, I'm open to starting with Q&As. I know during the introduction, I heard a couple of people say different things that was kind of on their desk right now. Are you guys okay with that, or you prefer I kind of start going through the slides with y'all? I hope I'm not talking too fast. Go ahead, Stacey.
Oh, no, I was just saying that sounds good to me.
Okay. All right. So I've seen a lot of people saying, let's go through the slides and we'll go from there. Okay. Yeah. And when we're in person, it's a lot easier to just start with Q&A because everybody's like, yeah, I got this thing on my desk that I want to talk about. Okay. So adverse possession. By definition, okay, adverse possession is just a legal doctrine that allows someone to gain ownership. Kind of the scenario that I just described. Tony goes to war, doesn't come back. The doctrine allows someone else to gain ownership of that property after openly. Like you can't sneak around. It can't be that you go in at night. It has to be openly, notoriously. Let me see if I can skip here to the elements of adverse possession, right? So the 5 elements, that's the actual possession, meaning you're actually there, right? You can't do it from across town. It has to be open and notorious, meaning it's against the owner's wish. If the owner knew about it, you know, Tony doesn't want you there. Tony just isn't there because he's at war. It has to be continuous. You can't leave and treat it like a vacation home. It has to be continuous possession. It has to be exclusive against the owner's interest, right? It has to be hostile, again, hostile against the owner's interest. So those are the main 5 elements that is required. But again, without getting into the legal jargon, just know that that's the idea behind adverse possession, okay? Criminal trespass, breaking and entering, that's a lot of what we see when vacant properties are quote unquote squatted, right? When squatters turn into your property that's on the market, that's just a criminal trespasser, right? Like, wait a minute. You can't just trespass on my property and then act like I'm out of line because you're a trespasser. I used to recommend just show up with a pistol, but that's frowned upon, right? We're not talking about the criminal trespassers. Call the cops, call the authorities in that scenario to say, nope, this is just a criminal trespasser talking about squatting, probably because they learned about squatting last time they were arrested. Catch for keys. So catch for keys is one of the things that we do talk about quite a bit. I used a scenario earlier where grandma was sick, Tony showed up to help grandma, grandma passed, Tony's still in the house. In that scenario, we might just be best to figure out a voluntary agreement where the owner pays Tony to get out, right? Tony's probably just there because he doesn't have any money for a hotel or whatever. So before I go litigating, I'd rather figure out a conversation whereby this squatter gets some dollars to leave. Call of title claim. It's one of those scenarios where people that are actually needing to use adverse possession can claim ownership, right? Using adverse possession because maybe during their signing, their closing at the title company, certain signatures weren't validated, or maybe they forgot to sign an important piece of document, right? So the call of title claim is where there's a defective or invalid document. No harm, it was just somebody's mistake created a document that wasn't properly signed, right? Like I said, continuous possession, that's one of the 5 elements of adverse possession, and that's that occupancy is maintained for the full statutory period without interruption. Eviction. Eviction versus ejectment. A lot of us in the real estate space probably know the word eviction a lot more than we use the word ejectment. So eviction is just a legal process, right, that we use to remove a tenant or occupant that no longer has permission. But there was prior permission, right? Ejectment, on the other hand, is to remove squatters and people that have no legal right to be there, right? So where an eviction might be able to happen in a JP court, an ejectment would be more of a circuit court, district court type scenario. So that piece of possession is another one of those elements of adverse possession where the person, right, the quote unquote squatter, controls the property without sharing possession with the rightful owner, right? So that if I let a friend move in and the friend got lazy and stayed too long, and they're like, well, I'm a squatter now. No, you don't have exclusive possession because you're actually sharing it with me as a rightful owner, right? Forcible detainer is one of those eviction words where that's a legal action that we actually use to regain possession of the property, right, from someone that's unlawfully occupying it. Will you hold over tenancy and tenancy as sufferance interchangeably? And they both basically just means you're there without permission, right? But at one point you had permission, right? So although an holdover tenant is the person that their lease expired in January, some leases, I don't recommend it, but some leases will say, hey, after your lease expires, you just go on a month-to-month basis. Not a fan of that, right? Some people, different landlords have different reasons, and bless our hearts. A lot of us as landlords, we're just kind of learning as we go, you know, similar to parenting. Like there's no big book about it, or maybe they are, you can read them, but we still can agree, at least the mom and dads in the room can agree that, yeah, man, it was a lot of just, I figured it out, you know? So I feel like a lot of these landlords are doing that. And some of them swears by, hey, once your lease is over, I want you on a month to month. I'm not a fan, right? Once your lease is over, I recommend an extension of your lease or leave, right? An extension or leave. So the people that don't leave and that don't do an extension, to us, I'll call them a holdover tenant, right? And again, tenancy as sufferance is just kind of the more of the legal word that we use for it, but they both mean the same thing. So these different contracts, this different holdover is discussing these different contracts, right? So in our 1 to 4 family, paragraph 10 talks about it as a tenancy at sufferance, right? And the 1 to 4 is a resale contract. It's about purchasing. But paragraph 10 is where it talks about when will the actual possession happen? When will we switch? When will the key be given out? So paragraph 10 says either A, based on a temporary lease agreement, or at closing. So paragraph 10 is saying if the person moves in prior to closing and they become a tenant, then they become a holdover tenant if they don't perform as expected, right? Then of course, paragraph 22 of the lease agreement speaks on what a holdover tenant is. And paragraph 22 is basically saying, look, if you overstay your lease, right? So lease expired, you didn't do an extension. Maybe you're waiting on your new house to get built, right? And you're just kind of there. Then you're on holdover tenant. For me, before I let a tenant become a holdover, I'll send a lease extension that says, hey, if you don't sign this before the expiration of your lease term, then you're an holdover tenant. And by law, the rate to be a holdover tenant is 3x your rent. So if the rent was $2,000, my notice will sound something like this. Hey, please renew your lease before this date. Otherwise, your new rent amount starting on October 1st or whatever your lease would expire, starting October 4th, your new rent rate is $6,000. They usually get their attention pretty quick to either A, renew their lease, or to start making arrangements to not become a holdover tenant. And then, of course, paragraph 19 of both the buyer's and the seller's temporary lease agreement for when you're doing a purchase with a lease back. Paragraph 19 also discusses what a holdover tenancy is and how to treat it. Okay. So a notice to vacate is a formal written demand asking the occupants to leave a property before you start legal proceedings. Open and notorious use, that's another one of the elements of adverse possession that basically says the occupancy has to be obvious and visible, right? You can't be sneaking around. It can't be just at night. It can't be just when the weather's bad. It's got to be like the actual owner would use it, right? Open the garage door, go to work. Open the garage door, come back in. Not using some kind of back door alleyway to get in and out.
So I have a question.
Possession. Yeah, please.
So I have a client who's trying to sell her house, but her grown son will not move out, nor will he even unlock his bedroom door to let anyone see his bedroom. So, she thinks she's going to have to evict him, and go
Yeah.
through the courts to do that. Is that correct? Should she like start with the notice to vacate?
Yeah, because he didn't really do any illegal piece to get in, right?
Mhm.
So yes, he's more of just he's just kind of a jerk,
Yeah.
right? And I
Yeah.
like us to kind of differentiate between all of that, right? And we have this conversation, it's like, okay, am I really dealing with a squatter? Am I dealing with a jerk? Am I dealing with a criminal? Like, is this a tenant gone bad? But in that scenario, yes, it's somebody that just kind of overstayed their welcome,
Right.
right? And back to the conversation earlier about cash for keys, that might be a good solution to say, hey,
Yeah.
look, kid, I don't know how much dollars is it gonna take for you to get out,
Right.
you know, because I'm about to spend at least that amount on legal fees.
Yeah.
And I kind of like you. I'd rather you take this coin and go than me have to air out our family's dirty laundry by taking you to court,
Yeah.
you know? Yeah.
Yeah.
No, good
That's a good
question.
idea.
Yeah. So I like the question. I'm not able to always check the chat. So just again, do like she did and voice your question as they come up. so that I'm not in my zone kind of talking through the slides while your hands are raised or something. Feel like we're in the room, raise your hand, unmute yourself, and say something, and I'll answer your question. Okay, so some people would like to act like, oh, you abandoned the property, that's why I started squatting. So here's a proper definition of abandonment: is when an owner relinquishes possession and control without the intent to return, right? So again, kind of that scenario where somebody went to war and they probably meant to return, but based on whatever happened at war, they're not intending to return. They're stuck somewhere, you know? Then a quiet title action is just a lawsuit to resolve disputes over property ownership or to remove adverse possession claims. Squatter, by definition, is just an unauthorized person who enters or remains on property without the owner's permission and without a valid lease, right? So that holdover tenant, part of why I don't like the idea of a month-to-month is because you start to kind of parse the language, like, yeah, I'm here, I don't have a lease, right? I'm here, and the owner's permission is there, but is it really, you know? So no, that's the idea of a squatter, is just an unauthorized occupant enters and remains without permission and without a valid lease. Of course, a trespasser is somebody that enters without permission but has not established residency, right? So when we think of trespassing, most of the time, how we just think of the person that's kind of cutting across your yard, right? But it can rise to the level of when it's actually just there inside the house, right? And I think that's what a lot of these quote unquote squatters are, is like, you don't have permission to be here, right? And they're just kind of hanging out, trying to establish residency. Unauthorized occupant, similar to a trespasser, right? Anyone living on a property without the owner's consent, okay? Including squatters, holdover tenants, or unapproved subtenants. And then vacant property risk is exposure to unauthorized occupancy, vandalism when a property is not occupied. Okay, so we talked earlier about kind of why adverse possession is on the books, even though it just sounds like such a bad thing, right? The idea is we want the best use of land, always. As a society, as an economy, we always want the best use of the land, okay? And so the adverse possession laws are on the books to help clear up issues that will minimize the best use of the land, okay? So there's really three main ways, three statutory requirements, right, for you to be able to get adverse possession. The first one is just a 3-year requirement, 36 months, okay? And that's based on kind of the mistake scenario, right? I bought the property, but I didn't sign all the right documents, right? So that's what we'll call a color of title, okay? There's no problem with the previous owner. There's no problem with the next. I just didn't have all the right documents. And so I need to use adverse possession to say, hey, due to color of title, I'm claiming adverse possession on a property that I've been in and became my own squatter, right? But because my documents weren't perfected, I need to perfect those documents. And that has a 3-year. Once you've been in that property for 3 years, you can use that to cure that defect. The 5-year requirement says that I've been paying taxes and I have a recorded deed, but I need to clear up whoever else might have an interest in this property, right? So I've been paying taxes and I have a recorded deed, right? And I've been here for 5 years, and I meet the other requirements of openly, notoriously, exclusively, hostile, those requirements. So that's a 5-year requirement that says if you've been in that property and you're doing those two things, paying taxes with a recorded deed, then you can file for an adverse possession claim to quiet the title. And the one that I've been describing is the 10-year requirement. So the previous owner disappeared, abandoned the property, and then I showed up cultivating, using, enjoying the land like they would for 10 years. Then I could file for an adverse possession claim. There's a 25 years that we hardly ever talk about because it's reserved for, I think the right term is like MHMR. So if there's any kind of mental health or mental retardation involved, then we would allow this very exceptional scenario at 25 years, okay? But we talked about the 5 elements earlier. Got to be actual possession, open and notorious, continuous, exclusive, and hostile against the actual owner. So to kind of take a deeper dive into the 5 elements, and I think we probably mentioned this during the terminology, but actual possession just means just that. You're living there. You're maintaining the property. You're fencing it. You're making improvements. You have actual possession, right? And you're using it as a normal person would, as a normal owner would, okay? Open and notorious, right? It has to be true. It has to be, you have to live in it like the true owner would, okay? So that the true owner can have a reasonable opportunity to discover the occupancy, right? So you can't sneak in and out before the sun comes up. You can't sneak in at night, sneak out in the morning and say, oh, I've been living here for the last 10 years. No, it needs to be obvious and visible. And it has to be uninterrupted, right? Continuous possession has to be uninterrupted for the full statutory period. Exclusive, right? So you have to possess the property alone without sharing control with the owner or the public, right? So this is what wouldn't allow, you know, let's say you and your siblings own the property and one of your siblings think that they're doing more work than everybody else. And they're like, well, I'm going to adverse possession because you guys are, no. You possess it along with them. So you can't at any point just say, oh, I'm taking adverse possession because you guys didn't mow the grass for the last 10 years, or you weren't helping me pay the taxes or whatever, okay? And then hostile possession doesn't necessarily mean that you're aggressive, right? Even though that's usually what we use, how we use the word hostile. It means without the owner's consent, okay? If permission was given at any point, then adverse possession cannot occur, right? Because it's like, hey, at one point, I gave you permission to be here. You overstayed. You're not an adverse possessor. You're just kind of I like to call him a lazy tenant that refused to move. Okay, and we talked about this earlier, right? So the public policy for adverse possession, okay, the idea is not to reward trespassers, but more so, if you will, to penalize neglect. Okay. The doctrine is supposed to incentivize owners to monitor and protect their property while preventing absentee ownership from freezing land in limbo, right? So that if somebody did disappear, went to Mars, never came back, then this doctrine encourages the best use of the land by not having it stuck in limbo. It allows somebody else to kind of step in your shoe. And if they step in and do those things for long enough, then that's the idea behind why it's even on the books. Okay. Again, I'm not a fan of the word litigation, but it's part of our economy. It's part of our society. Part of what adverse possession does is it reduces litigation, right? By setting all of those elements that makes it kind of clear at a quick glance if this person that's claiming this thing meets the elements. If they do, then we move on to step 2. If they don't, then it's a moot point. There's no conversation past that. So again, it's not, adverse possession isn't about legitimizing squatting. It's about having a doctrine in place to help us acquire title and stabilize property rights. Okay? So a couple of different ways, right, to get people out of a property. Senate Bill 38 is the new, well, it's almost March. So January 1st of this year, Texas Senate stepped in and said, here's a new way to get people out of homes quicker, at least as far as evictions, okay? Part of what it did is, so prior to this bill, I file an eviction, my tenant can appeal it and buy themselves some more time, okay? That might be another month, that might be another quarter of a year. It was bananas, okay? So part of what Senate Bill 38 says is, once I file an eviction, if I do it well, all the right paperwork, then the court can issue a summary judgment to get the tenant out. And if the tenant wants to appeal, now the tenant has to pay a bond, which is usually equal to at least 1 month's rent, okay? But prior to that, it costs the tenant nothing. I'm the one that filed the eviction. I'm the one paying the mortgage if it still exists. I have all this money coming out of my pocket as the homeowner, and tenant's just there filing, responding to the eviction notice, and then appealing without any skin in the game. So part of what's happened recently is the faster eviction timeline is because the court can look at the documents and say, yep, we're going to issue a summary judgment on the eviction request, and then ask the tenant to pay a bond in order to appeal, right? So that's how we remove people that at one point had permission, tenants. It's an eviction, okay? This doesn't apply to title disputes. It's supposed to be streamlined, right? Because most eviction cases should be. One of my favorite things to say when I played in that property management space a lot was, if you don't pay, you don't stay, right? That's just what it boils down to. You don't pay, you don't stay. Actually, that's what all of it boils down to. Even as a homeowner, if you don't pay your mortgage, you don't stay, right? That's what it boils down to. So that's Senate Bill 38. Faster evictions, it's designed to clear it all up and not allow a tenant to game the system, okay? Senate Bill 38 doesn't change adverse possession laws, right? Instead, what it's doing is it's reinforcing the idea that evictions are not a place where you litigate. Like, if there's a problem with a tenant, the tenant doesn't just get to stay in the house while this thing plays out in court for a long period. And part of what I like to encourage landlords to do is, yep, there's the ones that are just so right about, man, I'm going to court to go fight for this eviction. But I'm still a big fan of that EDR, as I described it earlier, to say, look, this is just an early dispute resolution issue. And at the end of the day, we can have a conversation with this tenant and the landlord at the table. And it might be that whatever we would have paid to go file an eviction and go through all of this litigation process is all it takes to get that tenant out today, right? So back to that cash for keys. Let's talk through it. Hey, tenant, I'm about to have to go trigger all this legal action. But before I do, let's see if we can work out a conversation where we figure out a way for you to leave within the next 48 hours, right? And it might just boil down to a catch for keys situation where the tenant was like, yeah, man, I've been staying here because I just needed money to get back to Georgia to grandma or whatever, right? I'd love to facilitate those kind of conversations to minimize the sleepless nights and the headaches for everybody that's involved. Okay? Now, on the other side of that, and this kicked in September 1st of last year, is Senate Bill 1333, okay? So we just talked about Senate Bill 38. That's designed to get the eviction process a lot more streamlined, okay? Senate Bill 1333 is designed for the criminals, okay? So the issue of criminals showing up and taking over deeds and trying to take over properties was so, I think the word we used was, it was a pandemic, or it was almost a pandemic, right? It's a big problem, okay? Bad enough that the Senate showed up and realized that they need to put something on the books that makes it easier. It makes it easier for us to get criminals out of our homes. So that's what Senate Bill 1333 does. Okay? So the homeowner can submit a sworn affidavit that alleges the unlawful occupation. I think there's a couple of people in the introduction that mentioned their scenario where this would be fairly effective. Okay? Owner submits a sworn affidavit alleging unlawful occupation. The sheriff, and it's pretty fast, right? Of course, you pay all the fees and all of that. The sheriff shows up almost immediately, right? And gets them out. Okay? And part of what the Senate Bill 1333 does is increases or clarifies the penalties for fake deeds, fake leases, fake claims, false claims of ownership, right? Partly because this organized squatting, it's a thing. Like, it's multi-million, probably closer to billions now. It's an underground illegal black market, right? And so that's part of why Senate Bill 1333 shows up to say, if and when you have that criminal, right? There's no other word. They want to call themselves squatters or whatever, but no, you're not a squatter. You have a fake lease. You have a fake deed. You false claims. 1333 helps us get the property back a lot easier. Okay, and it's limited, right? It doesn't apply to tenants, right? It doesn't apply to legit tenants. And it's not about family disputes, right? So back to the question about, hey man, this kid just won't leave. That wouldn't work for them, right? 1333 will typically require somebody using some kind of fake document, right? Some kind of fraud, even if they don't have a document, but they're just talking lies and using a fraudulent means to get access to the property. That's what Senate Bill 1333 is designed to address. Okay, thoughts, questions, feedback so far? Thanks. So, we talked about this earlier, right? The eviction versus the ejectment. Eviction is Senate Bill 38, right? Where you're trying to recover the possession of your property. It's not about ownership. We know clearly who's the owner here. It's just, I need to recover the property because this person is no longer welcome to be here. So that's an eviction. So it's prior permission. Now we want the property back. Ejectment is what we use when there is issue about the ownership or the title. Okay? So an ejectment would be used to recover possession and establish ownership, rather than just recovering the property in a eviction scenario. So as agents and property owners, some of the risks that we face as we have to deal with this issue is, of course, a clouded title, right? So that if there's a squatter or if there's not a clear title, then title company may refuse to insure until the issue is resolved, right? Delayed closings, right? While we're trying to figure out how to get the people out, is another one of those issues that we can expect. One of the risks to having a squatter or a tenant overstaying their welcome. And I love my title company, so we talk, probably daily, and we do see a lot of that where they're just not able to move a transaction. They can't move it along because there's a cousin or here that's not playing ball and squatting or doing something along those lines. Okay? And most of the time when you have that issue, then the owner may be forced to file a quiet title lawsuit to formally eliminate the adverse claims, right? Even if the squatter never legally qualified. So these are kind of the risks that we see. The clouded title issue, the delayed or canceled closing issue, and then of course the quiet title lawsuits to clear up any issues that might be outstanding. So I always like to share this part about, the disclosures. There are several different types of disclosures, seller's disclosures that we can use in a typical transaction. And none of them really speaks to if there's a squatter or somebody along those lines in the property, right? What I like to always say is, if a problem affects the marketability of title, then it needs to be disclosed somewhere to the buyer, right? You can't have a property that has a squatter on it and think it's okay to not talk about it because there's really no, or maybe you're hoping that by the time you sell, they'll realize there's a new owner and then, So there's no specific place in the seller's disclosures notice to check a box if there's a squatter or if there's a problem along those lines. But I would say that it's a material issue because it can affect marketability of title, ability to finance or refinance, or the buyer's intended use. So let's do ourselves a favor and figure out how to properly disclose that if you do find yourself at the table of a transaction that involves that, right? I think it's real important to minimize our E&O claims. So best practices. I was going over this pieces one day, and a lady was like, "Yeah, man, look, we have a property, and we went and did a routine inspection, and then like within 24 hours, somebody had moved in and like had the house fully furnished, pictures on the wall, like it was a whole thing, right?" And again, I think that's part of why Senate Bill 1333 got kicked in, because that was a very organized person, maybe entity, right? Maybe groups of people and entities that are able to, within overnight, move in and have the apartment or the house or whatever fully set up, like they've been in there for months, right? And so that if you were to call the cops in that scenario, even the cops, the optics of it plays in everybody's mind, like, what is this a bad dream? Like, the officer shows up and it looks like this person belongs. Like, they've been here for a while. They got their stuff all the way put up. So you can protect the properties, right, by doing routine inspections. but it's usually not always enough. Okay, having property management agreements in place. I know some of us in this class are property managers, right? Um, security systems. I think nowadays it's too easy to have, camera system that's portable. Right now, of course, the camera system might require some kind of internet piece, okay? But hotspots, whatever. So to me, it's a lot cheaper to put those pieces in place than to try to figure out how to deal with somebody that moved in. Mostly a criminal, but still, right? So it might be that there's a hotspot that you figure out a place to kind of hide the hotspot in the house, and you set up some cameras on your vacant properties. Okay, it's an expense, but cheaper than having to litigate. No trespassing signs. It doesn't sound like much, but it's a thing, right? Some of the people that would squat go, I didn't say no trespassing signs, or it was vacant. It was whatever. Those small signs go a long way. Okay. I've talked about this earlier. Lease termination and handling holdover tenancy. If the lease expires, renew it, right? I think that because of some of the moratoriums that happened during COVID, some landlords are still kind of gun shy about, well, I don't know if I want a lease in place. I'd rather just have them kind of there on a month-to-month basis, so it's easier to put them out. There's some fallacy in that statement, right? If somebody's in your house, it's in your interest and your bank's interest. It's in everybody's interest to have a lease in place. And even as a tenant, I don't want you to be able to just put me out. Like the kind of tenant that's okay with just being put out with a 30-day notice, you don't want them around you. They're too transient. Like, no, I need to know that me and my family can count on being here for the next year because we're making plans, right? We got a trip coming up. I don't need you to give me a 30-day notice in the middle of my trip that I need to hurry up and get back home and start looking for a new place. So, preventative measure. Do a lease renewal. Minimize your use of that month-to-month stuff, okay? And of course, maintain utilities and landscaping to show active ownership. I'm a big fan of the utilities part. One of the scariest things is walking into a house to do a showing or open house and there's no power. My client needs to use the restroom. And I don't know if you've ever walked into a house after the restroom has been used in Texas in July and not flushed. It's very scary. So maintain utilities. Yes, it's an extra couple of dollars. Yes, it's an extra few $100s, whatever. One of the things that I always try to remind us is, look, we're in real estate. So anytime we're at the table, anytime we're having a conversation, it's probably expensive. Not because we're bad people, just because we're talking about real estate. Okay? And so get comfortable with that so that if I tell somebody, hey, we need to spend money to keep the utilities on, it's just because you chose to be in real estate and it's an expensive hobby, expensive sport, expensive industry. But yes, maintain utilities, water, electricity, and of course, landscaping to show active ownership. And of course, my favorite part, because I am a mediator, work with mediators. There's too many misconceptions about mediators. Let me see, I think I saw a message here. No, there's too many misconceptions, okay, about mediators and what we do. To help clear up what a mediator is, let's use Judge Judy, okay? Most of us are familiar with the different Judge Judys of the world, right? So all these different judge shows, okay? Even though Judge Judy used to be a judge, when we're watching her show, she's wearing the hat of an arbitrator, okay? So I'm about to give us 3 different scenarios: a mediator, an arbitrator, and a judge, okay? The mediator doesn't get to decide the outcome. All we're doing is using our skill set and proven processes to facilitate a conversation where both parties can walk away. I don't want to say feeling like they both won, but feeling like they both won considering the circumstances, right? So the mediator is not going to give a binding decision. In fact, the mediator is not going to give a decision. The mediator is going to create a safe space for a conversation. And once that's done, usually you'll realize that there's just a couple of competing interests. And once we figure out whose interest is what, we usually find a pretty decent solution within a short period of time. So that's what a mediator does. It's not forced, it's not binding. Well, let me not say it's not binding. The mediator is not making a decision for you. You and the other side are making a decision on how you want to proceed. And then we, the mediator, will document that. And now you guys have a contract in place. So that if it was a cash for key situation, the mediator doesn't get to decide how much cash and when and all of that. The parties do. All the mediator is doing is facilitating the conversation, helping them brainstorm about different ways to solve the problem. And then as the mediator, I would document it, give you guys a copy, and case closed. If it was an existing case that was already filed, then you take that to the judge and say, hey, look, Your Honor, we solved it. No need to keep wasting the court's time. Here's our agreement that the mediator wrote for us. Please close the case. So that's what a mediator does. The arbitrator, on the other hand, does give a binding decision. Okay? Similar to a mediator, both parties get to choose what the mediator or the arbitrator is. Right? That's your decision. You could choose me, you can choose her, pick a mediator, pick an arbitrator. So when we see Judge Judy, right, that means those parties agreed at some point that Judge Judy will decide this problem for them. Arbitrators usually don't have to stick to the law. It helps, right? Because in theory, the law is supposed to be fair and equitable. But if you've ever watched Judge Judy, you will remember that she'll say something along the lines of, your opinion doesn't matter here. Nobody else matters but me in this courtroom. I did that. She doesn't have to apply the law. But because she used to be a judge, she does default to that. Cases where we see arbitrators a lot is like, I don't know, water rights type disputes, right? So we'll hire a expert witness, if you will, that is an expert, that's a subject matter expert in this industry to hear our issues and decide who's right and who's wrong. Okay? And that decision is binding, right? And we've agreed on that before we came in. So that's what Judge Judy is. She's an arbitrator in all of those shows. All the judge shows that we see on TV, arbitrators. We call them judge because I used to be a judge, but in this scenario, those parties have chosen them to be the arbitrator, okay? Then the judge that we're all used to, you don't get to pick that. The parties don't get to pick that. That's the big difference, right? Depending on the subject of the issue, depending on the dollar amounts that's being disputed, you get to go to a courtroom in your jurisdiction that has subject matter jurisdiction over that fight. You don't decide who the judge is. You don't decide anything, right? You just decide, hey, I'm filing, and the other side has to go respond to that, okay? So when I say work with mediators, it's so that you and the other side can have some control over who's gonna help us get this thing out, okay? And if at the end of that conversation, we don't have an outcome, then we could still go file our case at a judge or an arbitrator, but mostly with the judge, right? We could still go file our case, and nothing we discussed in the mediation can be introduced because there's a Texas law that protects the confidentiality of a mediation because we want to encourage it that bad. Okay, so mediation seems so foreign and so most of us don't know what it is, and so we're just like, we know it's a thing. It's just I hope the way I compared it to Judge Judy versus the judge helps a little bit in helping us have a better understanding of it. But that's exactly what it is your chance to confidentially, right? Because anything you file with the judge in a courtroom is automatically public information, right? So part of what the mediation does is none of that goes public. Now it's confidential. It's a lot quicker, right? Usually within 4 hours, we can figure out a solution, okay? And of course, the cost of it is a lot less than having to go pay for the court and the attorneys to litigate the issue. All right, finally, what I wanted to start with, the Q&As. Thoughts, questions, feedback. Otherwise, I'm gonna have us out of here in record time. I know a couple of people I'd mentioned at the beginning kind of the different issues that they were dealing with. Did we talk enough about, did we say enough things to help you figure out kind of how to move forward? I don't remember the exact names who said they were dealing with stuff as we speak. But feel free to unmute yourself and chime in.
I have a question about management agreements. Would you recommend that those get because I know that when we do them, it's kind of like that lease, like it goes into perpetuity unless you give a 30-day notice. Do you recommend revisiting those every year, every 2 years and revamping them, or just let it go until someone gives notice?
Yeah, I haven't done one recently, but I think you're asking about the property management agreement.
Yes.
Okay. So yeah. So what I would do is most, if not all, contracts will have a starting and an ending date. Okay. Once it ends, before you just say, oh, it's going into month to month, I would recommend just sending them an updated one.
Okay.
Right. Send them an updated one, especially if it's a relationship you want to keep. Right. If it's a relationship you want to keep, hey, it's been an awesome experience with you guys. Let's extend it for another, so that the new one, instead of the 12 months that you did on the first one, you might just say, hey, it's been great. Let's do a 36 month, right? Or maybe I could get you to commit to, in the commercial space, we're comfortable talking long term, right? So I might say, hey, look, if you go ahead and sign up for a 5-year property management agreement, I might be able to reduce property management fee by 0.5%, whatever, right? And now you know that you can bank on this contract for the next 60 months instead of just waiting for any given month that they show up and cancel it.
Okay.
Yep. That's one of the ways I like to give a business answer to kind of a legal question, right? Give them an incentive to sign up for a 60-month lease, a 5-year property management agreement with you, right? And if a lot of institutional people like those kind of contracts in place, because the institutional mindset, the financial institutions that is, say, hey, that's a recurring income that you have guaranteed by contract. So that's what I would do with that.
Okay, thank you.
Yep. Thoughts, questions? I have my contact information up. I'm sure everybody has done it, but another reminder, if you haven't, to make sure your name and license number is in the slides. It's in the chat. And and I'll keep answering the question, but we went through it. You'll get a recording along with the slide deck in your email. And I'll stay back to answer any more questions, but if you guys are good, I'm okay with finding a good stopping point. Oh yeah, the last slide, which of course our lawyers make us say this, right? We won't give them legal advice or tax advice. It's just an educational course. And so if you do find yourself needing to get some better advice, you can call, take it offline, or you might just need to check in with your favorite attorney. So I had a question here. What's the best first step if someone is on your vacant empty property? Yes, absolutely. Call the police, right? Call the police if you find yourself in that scenario. They're criminal, right? You have a vacant property and somebody is there. I don't know. Like I said, it's frowned upon, but I'm like, get your pistol, right? That's how kind of bad it is. It's a criminal issue. Call the police, right? And then of course, depending on who that person is, they might try to convince you that, hey, it's because your grass was tall, the house looked vacant, you know? And if needed, then it would be Senate Bill 1333, right? That gets triggered, which in that case, you find a sworn affidavit saying, hey man, someone is on my property. They're talking as if they have a fake lease, a fake deed, or whatever the case may be. And the process will get, police by default would like to treat that as a civil issue because the police doesn't want to be the judge, jury, and executioner of deciding who to put out and who not to. So by default, yes, you call the police, it's on record, but the police might not do much but just have it on record. And then you follow up with the Senate Bill 1333, which if you do find yourself in that situation, we can help with. Senate Bill 1333 then gets the ball rolling and gets the sheriff and the constables out there to possibly remove them. Okay. Another question, could you walk me through the eviction process step by step? Yeah, eviction by design is really, they're all unique, but yes, we could take that offline, Ariel. But ideally, you would start at your justice of the peace court. Well, before that, you've been wrong, whether it's because they didn't pay, so that you would have given them a notice, them being the tenant, a notice stating why you want them out. One of the things that Senate Bill 38 did well was to clarify how that notice can be delivered. To me, it's always been on the books. It's nothing new. But one of the clarifications is now that notice can be delivered via email, right? If the tenant had consented to email delivery during initial conversations, okay? So you get them the notice. And I'm a big fan of, there's a judge is just like you and I. There was a person and one day they got voted in or they filed an application, they got a job. So judges don't always get it right? And that's why we have different levels all the way up to the Supreme Court, okay? And the word we use in that space is infallible. I'm not infallible because I'm a judge. I might be right? Now, at the Supreme Court level, they don't always get it right, but the buck stops there, right? Anyway, so even though you can send it via email or post it on the door or this or that, because I don't expect the judge to always know which ones are okay and which ones aren't, I might just send it 3 or 4 different ways. I sent you an email. I sent you a certified letter. I posted it on the door, on the inside or whatever, blah, 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 right? Once you do that part, then you can wait the required period, which is 3 days, go to the court, file your eviction. Now, the court will depend on your address. Once you file that, you want to make sure you let the court know that you expect a bond if this person wants to appeal, right? But yes, I'll be happy to walk you through it step by step. You have my contact information there. That's kind of what it looks like in general. I believe you said you were out of the Houston market, but yeah, we play all around Texas. Okay. Yeah, Casey, I'd be happy to have a conversation with you offline about adverse possession. Have your contact information here. Awesome. So again, if you signed in with your license number and you don't have any other questions and you don't feel like eavesdropping on whatever else we're talking about, thank you. I saw some license numbers that started with a 3 and the 4s and 2s. I'm very grateful. Mine starts with a 5, but I'm always honored just to teach to people that have been doing this for so long, right? Because a lot of people don't make it in real estate. So for you to make it longer, and I know the process that I've had to go through to be here this long. So for you to be here longer than me, I salute you, right? So thanks for showing up. We'll keep doing classes like this just to keep educating ourselves about how to make money safely.
Thank you.
Absolutely.
Thank you.
Absolutely.
Hi, Damon.
Yeah.
This is Casey. I wanted to
Hey, Casey.
chat. I wanted to chat about the adverse possession issue. I didn't want to bore all the other guests, so I figured we'd take it offline.
People, we learn from each other. Those questions, unless there's, some personal details, those kind of questions allow us to all learn, because somebody else might be having a question similar, or they might not see it till 4 or 5 years later, and they're like, oh yeah, I think I do remember hearing something about that 4 or 5 years ago in the class.
Right.
So no,
right.
this is not something that's too personal. Yeah, talk to me about it.
Okay. So in 2007, my father-in-law passed away. He was old school. He was if he was alive today, he'd be 95. He was born in 1930. So he was very old school.
Like they still do stuff with handshakes and I bought 2 houses with the handshake and cash. I know those people.
Exactly. That was him.
Yeah.
He was one of those, I'll build you a house, I'll build you a shed, and you can just pay me like that. Or no, I don't want money, just give me some food. He was he's from
give me the
Louisiana.
title to that Chevy in the back. Yes.
Yes.
I like that. That's why I can relate.
Yes, he was from
I've been known
Louisiana.
to work for some good cookies. Yes.
Yeah, he was from Louisiana. He's, he was a older black man. Everybody in the world knew him, and he was just as kind-hearted as everything. He always told us, a stranger will be there before your family. So anyway, bottom line, in 2007, he passed away. He had an aneurysm. He was such a hard worker. 2 weeks before he passed away, he was literally on our roof, and we were doing a roof, So he, like I said, he was amazing. But at the same time, he was very, just nonchalant, didn't give a crap about anything. Yeah.
Yes,
So
I love it.
Bottom line, 2007, he passed away. We've been paying taxes. My husband and I been paying taxes on that piece of property. His house, he had probably 3 houses on there at one time. Every one of them burnt down. He just would
What county?
Do what? Harris County.
What county was this?
Harris County.
Okay.
Yeah. And so bottom line, when he passed away, he had about probably 5 to 10 years of taxes not paid. So on top of
Okay.
paying so we went ahead and paid all the back taxes that we had no idea, because he was one of those people, he didn't tell nobody his business.
Yeah.
And so we paid all of his back taxes. We paid every year since then. So, and that was back in 2007. So it's clearly been almost now, what, about
Yeah, going
19,
on 20.
20 years
Yeah.
now, going on next year. So anyway, we decided, and we go over there once a week and we mow, and there's nothing on the property. It's only a little 10,000 square foot property.
Okay.
And we mow it, we maintain it. Well, we decided, you know what, the neighbors are getting too close. The neighbors are trying to, kind of encroach on it. Let's just get a fence up. So I called not the title. I called the survey, and I said, hey, let's get a survey so I can get this fence up. Well, took a couple of weeks, and she just kept saying, Casey, we have issues. Give us a little bit longer. Give us a little bit longer. About a month later, she's like, Casey, we had to work our tail off on this. I'm like, what's going on? You always have my surveys within 10 days. And she's like, yeah, we worked our butt off on this. She said, your father-in-law, he is not on the deed. And I said, what? He
Wow.
owned this before my husband was born in 1962, and he owned it
Okay.
before then. I think my husband
Okay.
said he got it in the 50s, 1950. And
Okay.
they lived there their whole life. That's why my husband always wanted to pay taxes on it, because that was his childhood. They lived there their
Yeah.
whole life. So bottom line is, she's like, yeah, we can't find him on the deed. I'm like, what are you talking about? He literally lived there. He had probably 4 homes there, 3 of them burnt down.
Yep.
My husband was raised there. What do you? I said, we have the taxes, and they're all in his name. I
Yep.
pay him every year. Now they're in Barnabé Estate. But they're yet,
Okay.
but yet they come to me. So
Okay.
I said, what do I do? She said, girl, I think you need to hire a lawyer. And so I hired a lawyer, and my lawyer said, you need an adverse possession lawyer. She
Yep.
said, I cannot find anything to connect his.
Yep.
Now let me back up. The survey company, they investigated. They did so much. That's why it took them a month. She said, we did
Yeah.
end up finding in 1958 a older
Mm-hmm.
gentleman, and I can't remember his name. She said his name was da 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 da, and she said, I don't know if there was some sort of communication between your father-in-law and him, or something written on a napkin, or something that
Yeah.
maybe was drawn up, that maybe was in a fire, one of many
Anything.
fires,
Yeah.
anything. We have no documents. And there's literally, she said, we went back to the county records, we went back to everything. She said, we can't find anything. And I'm like, are you
Yeah. It
kidding me? I've
happens.
been
I've
paying
seen
these
it
taxes
before.
all these years. What do I do? And
Yeah.
that's when she
It's
recommended a
something.
lawyer.
It's there. Yeah. It's there. It's just not. It just isn't taught to him. But yeah, let me put a couple of things together. Let me ask one question, then I'll put a couple of things together for you. Did
Okay.
he die with the will? Do you know?
No, absolutely not. He had
Okay.
nothing. He was always one of those types. He didn't have anything,
Yeah, I
and what
can
he did have,
imagine.
he just knew. My husband was pretty much the only dependable, the only, all the rest of there's 5 other siblings.
How many siblings does your husband have?
5 other siblings, yes.
Okay.
Yes, and they
Okay.
all are in and out of jail. They're all
Yeah, I got you.
they have never, had a pot to piss in, a window to throw it
Yep.
out
Yep.
of,
Yep.
type
Yep.
thing. So my husband is the only
Yeah. So
reliable,
yeah, we've seen
dependable.
this. We've seen this before. The last one actually was similar, only the deed did exist but never recorded, right? So the dad had it in a bowl or whatever, like in the attic. And of course, we're talking about Houston. So one of the Katrinas or one of those big storms took it out. Okay. And so
Mm-hmm,
they did lose it through that
mm-hmm,
process. And yes,
yeah.
there's a whole process. There's the adverse possession would be your answer in this case. And what we would basically do is put all of this facts together, including all the siblings and whoever else might be an interested party. And the one I'm thinking about happened in Crosby, Texas, which is a small
That's where
town
I'm
there.
at. That's where I'm at.
Oh,
Crosby,
wow.
Texas. Yeah,
Yeah.
that's where I'm at.
So we'll put all of that together. I'll check in with you offline, Casey, and we'll help you figure out how to move it along.
Oh, that would be great because I really want to get
Yeah.
this going. I want to, yeah, I don't want to continue to pay taxes if I'm never going to get this thing again. I mean, I've already paid it for
You
20
paid
years.
enough to be worried
Yeah.
about who's gonna
Yeah, I
take
paid it
over
for
it. Yeah.
20
Yep.
years, and then the 10 before that, I paid taxes on this thing for 30 years.
Let me
And
ask one last question, Casey. Did you end up with the fence or no?
no, because we can't
That's it.
establish a survey
Okay.
because they won't proceed with it. They literally gave me my survey money back. She's like, we can't
Oh,
do this
wow.
survey. We can't find the deed. I'm
That's
like, oh
awesome.
my God.
Okay.
So we can't put a fence up legally because we don't have the boundaries.
Yep. I got you.
Yeah.
I'll
Yep.
call you. I have your number here. I'll call you and we'll walk through it.
Oh, thank you. Thank you. I appreciate it. I'm looking forward to talking to you.
Absolutely, Casey. Take care.
Thank you. Bye-bye.
Yep. Okay, Enrique, I see you're still here. Anything else? Good. Just a couple of other people. It seems like everybody else is pretty much done
All
here.
good. Thank you so
Thank you,
much.
guys. Yeah, absolutely. We'll see you around.